As you can hear, the problem has not been solved, unfortunately. We are going tomorrow to move into Court 74, which the case which is happening there today is going to be vacant, is going to finish, so that will be vacant. And someone can come in and hopefully sort it out without us being here. Tomorrow, I'm afraid we will need to start at 10:30, so you'll have to fight your way through the crowds if the crowds are still there. Thank you.
Thank you. My Lords, I would like now to turn to the second ground of appeal, which is no accessory liability, so dishonest assistance and knowing receipt claims. And I would like to start, please, by referring you to a couple of authorities. So if you please take the first authorities bundle, tab 2, where you'll find Royal Brunei Airlines and TAN, and at page 74 is the section where Lord Gough sets out the discussion about dishonesty.
Just before we start on this, did you manage to find out the date of the assignment?
Yes, I'm sorry. The assignment was on the 11th of April 2019. The payment to the fund by FCN Cayman was on the 17th of April 2019. That's at paragraph 345 of the judgment.
Payment 17th of April, you say?
Yeah. And the payment by the funds to FIML took place on the 12th of June 2019. And that's at paragraph 347 of the judgment.
Sorry, what was the third of those dates again?
It's 12th of June 2019.
Thank you.
And the documents we were looking at yesterday, before lunch were dated the 30th of May.
Yes, it was tab 20 of the supplementary bundle. 30th of May was the memo from the administrator, so that's about 6 weeks after the payment had been received. And then the written resolution of directives was the 5th of June, and then the payment was made after the 12th of June.
Do we have the assignment anywhere?
It's not in the appeal bundle. I understand it was in the trial bundle, so it could be made available. That would be helpful.
Okay, we'll have it then.
I'm sure we can produce that for you.
Thank you.
Sorry, I should have started with that, but if I might go back to where I was about to start, which is the authorities bundle, and Royal Brunei Airlines and TAN, paragraph, internal page 389, so 74 of the bundle. And you'll see the section sidelined here on dishonesty. This is the part of the judgment that the subsequent judgments refer back to. Where it was held that in the context, this is about at C, in the context of the accessory liability principle, acting dishonestly or with a lack of probity, which is synonymous, means simply not acting as an honest person would in the circumstances. This is an objective standard. At first sight, this may seem surprising. Honesty has a connotation of subjectivity as distinct from the objectivity of negligence. Honesty, indeed, does have a strong subjective element in it that is a description of a type of conduct assessed in the light of what a person actually knew at the time, as distinct from what a reasonable person would have known or appreciated. Further, honesty and its counterpart dishonesty are mostly concerned with advertent conduct, not inadvertent conduct. Carelessness is not dishonesty, thus for the most part dishonesty is to be equated with conscious impropriety. The two other parts I would like to draw your attention to. One is on the next page at 75, at the bottom, G to H, or perhaps F to H. The only answer to these questions lies in keeping in mind that honesty is an objective standard. The individual is expected to attain the standard which would be observed by an honest person placed in those circumstances. It's impossible to be more specific. and about 4 lines down, acting in reckless disregard of others' rights or possible rights can be a telltale sign of dishonesty. An honest person would have regard to the circumstances known to him, including the nature and importance of the proposed transaction, the nature and importance of his role, the ordinary course of business, the degree of doubt, and so on. And the last point here is over the page, these B to C on page 76. Likewise, when called upon to decide whether a person was acting honestly, a court will look at all the circumstances known to the third party at the time. The court will also have regard to personal attributes of the third party, such as his experience and intelligence, and the reason why he acted as he did. That, the broad principle of dishonesty was then endorsed by Privy Counsel Lord Hoffman in Barlow Clouds, which I don't need to take you to. I think the relevant passage is in fact cited in the next authority I would like to take you to, which is Ivy and Genting, which is tab 25 of the authorities bundle at page 826.
There's not really any dispute, is there, about what the test is? I know you say the judge didn't apply it.
I say the judge doesn't apply it. I think that's right. I understand there's not a dispute about the test. I'm just wishing to, by showing you the
Could hardly be in dispute with a host of House of Lords and Supreme Court cases, and they're all pulled together in Group 7.
And they're all in Group 7 then endorses what's said in Ivy and Genting. So,
I mean, take us to it if it adds to what we've just seen, but that seems pretty straightforward.
So the test, which is well known, which is established in Ivy and Genting, although this was of course obiter, because the case was actually decided on the basis that Sir Ivy was cheating in accordance with the Act by his edge sorting. This simply endorses the statements by Lord Nichols in Tan and by Lord Hoffman, Barlow Clouds and Eurotrust, saying when dishonesty is in question, this is at paragraph 74 at 851, when dishonesty is in question, the fact-finding tribunal must first ascertain subjectively the actual state of the individual's knowledge or belief as to the facts. The reasonableness or otherwise of his belief is a matter of evidence, often in practice determinative, going to whether he held the belief, but it is not an additional requirement that his belief must be reasonable. The question is whether it is genuinely held. But that's all I wish to emphasise from there. And then, of course, Group 7, because that was over, so Group 7 endorses that approach in Ivy. So why do we say the judge fell into error? The judge deals with dishonesty in his judgment at paragraph 359 onwards. That's page 4 bundle 187. And for completeness, I should note that when the judge deals with dishonest assistance as a cause of action, he does so at paragraph 473. But on that occasion, the judge simply makes, certainly in relation to the dishonesty element, simply says, I'm able to make relevant finding. He doesn't go into any further detail. So looking at 359, which is where it's headed, dishonesty in relation to termination. The crucial part of the judge's judgment is at paragraph 372. We've already seen previously at paragraph 367, on page 188, the judge found that the individual defendants had no confidence there'd be paid sums ultimately due to them because they did not trust Mutaz. As by reason of their lack of confidence and their distrust of Mutaz, the individual defendants acted to ensure they received 50% of the termination fee between them. The sum was first received by FIR and from there was received by Mr. Churchill, Mr. and Mrs. Diallo and by Mr. Nuseibeh. The money was due to the fund, and Mr. Churchill, Mr. Diallo and Mr. Nuseibeh knew it, that they decided to take it and keep it. That as it were, introduction to the findings of dishonesty, we say is not a finding that is that takes into account the circumstances in which it was made. It makes it sound as if they were entire strangers to the fund and the fund structure. They decided that they wanted the money and they took it for themselves. I appreciate, of course, this is just one paragraph in the scope of the judge's reasoning. But what that ignores, it's what it seems to put into the judge's mind, is ignoring the fact that there was a proper basis on which they might expect ultimately to receive this money, that it would be paid to Finland. And that they didn't just decide to take it and keep it for themselves. They negotiated with Mutaz, who was, of course, director of the fund, director of Finland, director of FCM London, sole shareholder in Finland. They negotiated with him as to how the profit from this particular deal should be dealt with. But the judge seems to have had a very narrow focus indeed and had simply ignored the wider context. So paragraph 370, the judge goes on to acknowledge and say a share of the reward of the termination fee might have reached the individual defendants when Fimmel was obliged to pay money to FCM London, and FCM London in turn declared dividends to its shareholders. Mr. Churchill arranged for half the money to be received and enjoyed by them regardless, and not go to the fund or to Fimmel for the fund. Indeed, they proposed and arranged for the other half, 2.2 million, to go to a destination that was to Mr. Mutaz Otayibi's personal financial benefit, i.e. FCM Claimant. So that shows, if it weren't already obvious, that this was an agreement made with Mutaz. This wasn't simply helping themselves to the fund's money.
How were the payments actually, the instructions were given to...
The instructions were given by...
To the fund solicitors?
Email from Mr. Nuseibeh to Burgess Salmon, the fund solicitors.
And that followed, and they included, did they? I don't think, I certainly haven't found them in the bundle, but they included an instruction or a direction for the payment to go to SCM Cayman as well.
Yes, I must just find that. I'll find the document reference for you, but yes, the instructions to the solicitors were to, because there was a whole discussion about whether it would be possible to split the termination fee 3 ways rather than 2 ways. Because originally it was 2 ways. There was a suggestion that it might be paid to a single entity, either IRL or to Fimmel, and essentially neither the individual defendants nor Mutaz, defendants say, trusted each other enough for it to go to either one of their companies.
So you send an email to the fund solicitors saying, please arrange for payments to be made in the following direction.
Mr. Nuseibeh did.
Yeah.
He had been, FCM London had been appointed by the fund to liaise with the fund solicitors in respect of the redemption fee. So the fact that the email came from Mr. Nuseibeh is in that context not surprising. He was named as one of the people from whom the solicitors could take instructions.
Okay, you may be, and the fund solicitors, had there been anything leading up to this? In a sense of the fund solicitors just received an email and just acted on it.
No, there had been a number of matters. There had been a draft termination notice had been prepared in December 2016. They had been involved in drafting which Mr. Whitworth signed in blank, which had a blank sum for the redemption of the loan and a blank sum for the termination fee. And then when Reading finally repaid the loan and the money came in, that seems to have been completed without Mr. Whitworth re-signing it. And the judge makes a comment that this wasn't out of practice, its lack of formality wasn't out of the way that the fund operated.
But Mr. Nuseibeh, sorry, I think you said a moment ago, the fund solicitors would have understood that Mr. Nuseibeh was entitled to give instructions in some way.
Yes, if I can, perhaps I can show you. It's at page 164 of the supplementary bundle. you'll see the beginning of the email, in fact, is on page 163. And it shows that the principal amount outstanding, 70 million, is to go to the fund, just under 1.1 to FIR, just under 1.1 to FCM payment. And you'll see that even in this email exchange, there are a number of exchanges between Burgess Salmon and Walker Morris, who Alexander at the wedding, and then Mr. Nuseibeh, Mr. Diallo, and Mr. Churchill are copied to some of these emails too. Does that deal with your lordship's point?
It does for now. So, yeah.
So, returning to the judgment, I was saying that the core part of the judge's reasoning as to dishonesty is in this section, but the core reasons appear to be in paragraph 372. Where the judge says, Mr. Churchill, Mr. Diallo, Mr. Nuseibeh appreciated that the fund had not agreed to this treatment of the US 2.2 million. They further appreciated that Mr. Mutaz Ataibi's authority, considerable though it was, did not extend to allow him to treat assets of the fund as his own, to apply to his advantage or give away for his own purposes. They knew it was out with the instructions, because it was not necessary for the US 2.2 million to be treated in this way in order to achieve early repayment of the financing. And the instructions, you may recall, is the shorthand that the judge used for the instructions in relation to the other two payments that the claimant sought to recover at trial. The instructions were by Mutaz saying, please recover the principal and don't worry about fees. It's the instructions that the judge found Mutaz gave. So
I suppose I'm going to just ask the question anyway. What were the fund's solicitors doing in relation to this? I mean, it's not. I'm bound to say maybe I'll have to ask the question of Mr. Jones, but it's not the usual modus operandi of a fraudster simply to ask solicitors acting on behalf of in this case, the fund, to make payments to which the fund hasn't agreed, and just for it apparently just to be acted upon. I mean, was there any evidence about how the solicitors came simply to say, yeah, okay?
My understanding is that Mr. Nuseibeh was authorised to give instructions to the solicitors on behalf of the fund in the process of dealing with this payment. I think the evidence at trial was that although, well, obviously Mutaz knew about it, Mr. Whitworth, I think his evidence was that he could have contacted the solicitors and he had one telephone call with them about the formalities of signing some document, but that happened to be the only contact that he'd had with the fund solicitors. But yes, when we come on to it and say, well, if they didn't believe that what they were doing was, at least in a broad sense, honest, in my submission, they wouldn't have gone about arranging the payments of these monies in the way that they had and getting Mr. Whitworth to sign things off on behalf of the fund instead of, say, Mr. Ataibi, Mutaz, who, of course, knew all about it.
And this was money which by now was sitting in the client account of Burgess Salmon and therefore held on trust for the fund. So on the face of it, any reputable firm of solicitors is only going to part with that on the basis of very clear instructions from a properly authorised source.
Well, we would say that Mr. Nuseibeh was properly authorised.
You say effectively he ticked that box. He was in that position.
Well, The suggestion, of course, that Burgess Salmon acted in breach of trust has been raised for the first time in my learned friend's skeleton arguments on this appeal. It didn't appear at any point below. But Burgess Salmon, as far as I'm aware, wasn't suggesting they might like to intervene or provide any evidence as to what they were doing.
I mean, coming to this case cold, there are two, as it were, dogs which are very vociferous in not barking. One is Burgess Salmon and the other is Nusaz. They're both, well, Nusaz in particular is incredibly involved in almost every aspect of the corporate structure. And yet here we find him basically suing to undo an arrangement which he himself played a very instrumental part in setting up, on the basis it was all a fraud on various other entities of which he is the alter ego.
Well, yes, I think one of the things that shifted, of course, very considerably as between the trial and the appeal is that at trial, of course, the claimants were saying that Mutaz was not complicit in any of this.
Yeah.
So the whole sort of factual framework as presented to the judge was that he was not complicit, it was just the individual defendants working on their own.
And in fact, I mean, as pleaded, the case against him was that he'd been kept in the dark until a very late stage about what was going on, and then, fault fast, he suddenly went along with it all.
Yes, and the judge, of course, then found that he gave his fully informed consent. He participated on an informed basis.
Yes.
In my submission, that's one of the ways in which the whole sort of structure of the case shifted. Because at that point, having made that finding, you might have gone back and said, well, actually, this all looks very different. It's one thing for the individual defendants simply to have done something by themselves and taken the money of the fund. And that's the way in which, in my submission, the judge has gone wrong at paragraph 369, simply saying they knew the money was due to the fund, but they decided to take it. The judge didn't step back and say, well, actually, they didn't just take it. They knew they had to get agreement. They got agreement from Mutaz, who is a director of the fund. They were authorised by the fund to give instructions to the fund solicitors, and they did so.
And the fund solicitors must have not thought there was anything untoward, because otherwise, why are they just...
One assumes so. One assumes
or
nothing...
More to the point, as I say, if you're about dishonestly to commit a wrong, targeting the fund, a substantial firm of solicitors as the means by which you're going to do it is not usually the starting point.
Absolutely. Given that Mutaz was involved, that's part of the shift. Given that, as the judge found Mutaz was involved, if there had been an intention on the part of all of them to conceal this from the fund, one would have expected Mutaz to be signing the deed of release in December 2016. One would have expected Mutaz to be giving any relevant instructions because the authority would more clearly come from him. There'd be no need to involve Mr. Whitworth at all.
I mean, on the judge's findings, it seems that Mutaz and the individual defendants are equally honest or dishonest, as the case may be. It's hard to see that the individual defendants could be dishonest if Mutaz wasn't also dishonest.
It's possible, of course, that they would have different subjective beliefs as to what they were entitled.
Well, not on the judge's findings, because he finds that Mutaz equally knows he's not supposed to be doing this.
He says that Mutaz has a lot to answer for, certainly.
But you said a moment ago the defendants didn't think they were doing anything dishonest, but as you've shown us from the cases, that dishonesty is an objective test. Isn't the position that one has to identify their actual states of mind, which I think you're saying to us are that although they knew that they were not entitled to this payment, nevertheless they believed that it would be coming to them in due course. And the question then is whether diverting it straight away, what you call a contractual shortcut, is objectively honest or not. Is that the analysis we have to consider?
Yes, there are two elements to what they believed. And the first element, we say, is that there were no findings as to exactly what they believed Mutaz's authority was. The judge says, and this is paragraph 372 where I was just getting to, the judge says that the individual defendants appreciated that the fund had not agreed to this treatment of the 2.2 million. But of course, that only holds good. There's no specific reasoning on that point, which is indeed one of our specific grounds of appeal, the lack of reasoning of this part. In order to make that finding, the judge would have had to find that the individual defendants did not subjectively believe that Mutaz actually had authority. Now, the judge found that he didn't, but there would need to be a finding that Mutaz did not have authority to deal with this termination fee in the way that he did. Because what the judge finds is he really asks an inapposite question by saying they appreciated that Mutaz's authority did not extend to allow him to treat assets of the fund as his own to apply to his advantage or give away for his own purposes. In my submission, that's a very different finding from the relevant finding that the judge should have been considering. It's one thing to say, did you believe that Mutaz could simply hand out all the assets of the fund, including, presumably on this basis, all the assets, all the principal owing to the shareholders, all the interest that would need to be paid to the shareholders? That's the import of the finding that the judge made, and even that is without, isn't clearly reasoned. But that isn't the right question. The right question is surely, did the individual defendants believe that Mutaz had the fund's authority to deal with this sum in the way that he did? And the context of that is the fact that Fimmel was entitled, under the contractual structure, to any profit. And the fund had been making profit from the Reading transaction. It had been paying an interest rate of, I think it was 8%. The shareholders were due 5%. This left a whole 3% worth of profit, which might cover funds or cover expenses or any incidental costs. So this termination fee was on top of all of that. And the question is, did the defendants believe that Mutaz was actually entitled to deal with this? And we say that's not a finding he made in the right terms. He simply said they believed that Mutaz could not give away the assets of the fund. If we've been talking about the 17 million, so that all the shareholders, investors lost out, that would be one thing. But that's simply not what happened in this case.
Where did the judge's phraseology come from about giving away for his own purposes? I mean, that was it something that arose in cross-examination, or was it another one of these findings he was invited to make?
I'm not absolutely sure. It's not. This part isn't in response to. It's not like.
No, it's not, and that's why I was asking. Yeah.
Find it.
I mean, it may reflect the way submissions were put to the judge. I know not, but on the face of it, I take your point. This doesn't really grapple with the essential complaint in this particular context, or at least arguably it doesn't look as though it's properly grappling with it.
So, where the judge, the key point in my submission is that this isn't the essential question what the individual defendants believed. And so, if we start from the position of saying that the judge really ought to have addressed Mutaz's authority and what the individual defendants thought about that, he would have had to explain it in some detail, given the evidence I'm about to show you. There's one other point I'd like to raise at this point, which is, because there seems to be no reasoning here, you might look at what else is said, and the other part of reference is paragraph 338 of the judgment. And this refers to a legal finding, as it's put at 610. Legal finding 610 at paragraph 333 on the previous page. The fund seeks this finding. The individual defendants could not reasonably have interpreted any act by the fund as giving Mutah's authority to agree to the fund not receiving the payments in circumstances where they had at least constructive knowledge of the break fee clause in the NAV asset requirement in the offering memorandum, and therefore ought to have known that any such decision involved the fund breaching its contractual obligations to investor shareholders. And at 338, the judge says, I'm able to make finding 610 in relation to the termination fee, including what the fund describes as the diverted sum in this way. Mr. Churchill, Mr. Diallo, and Mr. Nuseibeh could not reasonably have interpreted any act by the fund as giving Mutah's authority to agree to the fund not receiving the termination fee that was to be paid, and to somebody else receiving it instead, in circumstances where Mr. Churchill, Mr. Diallo, and Mr. Nuseibeh knew that the right to the termination fee was the fund's. In my submission, this essentially goes down the same path. First of all, it's put by the claimant as a legal finding, and indeed it doesn't make any finding as to what they actually believed. It simply says they could not reasonably have interpreted any act by the fund as giving Mutah's a certain amount of authority. So this seems to be going to a question of...
what is meant by a legal finding? It's in some respects a contradiction in terms. And you find facts and you hold matters of law.
Well, the claimants would have to answer that question. But in terms of what the judge...
Well, the requested finding seems to be all about what they could reasonably have done, constructive knowledge, and what they ought to have known.
Yes, it's not about what they actually did know.
Yeah.
And of course, the same flaw occurs here in the third line up, 338. They didn't receive Mutah's authority didn't extend to agreeing to the fund not receiving the termination fee that was to be paid, and to someone else receiving it. So it's the same problem. The judge is imagining that this fee is just being paid to anyone. It's just being entirely unrelated third party.
If they couldn't have reasonably interpreted the fund as giving that authority, what were the solicitors doing? Presumably the solicitors couldn't reasonably have thought that they would be the instructions they'd been given were appropriate either.
Well, there are no findings by the judge.
Well, no, I know there aren't. But
I would.
It's my lord's dog that isn't barking very loudly.
Bark. If there was something so obviously wrong with it, one might imagine the solicitors would have sought further instructions.
Was there any factual investigation of a point like that at trial or in the evidence?
My understanding is that there wasn't a factual investigation of exactly how Burgess Salmon held the money, for example.
Well, if it's in their client account, that's as far as we need to go, isn't it?
My learned friend would have to speak to exactly what happened at the trial. He may be able to help you further.
And the judge's reasoning seems to begin and end with the fund's contractual entitlement to receive the money, and doesn't go on to consider what happens to the money once it gets to the fund. Save where in the paragraphs where he refers to it being retained as part of a quarterly valuation.
Yes,
he says that in 2 or 3 places.
Exactly. In my submission, he has an unduly narrow focus. It simply focuses not only on saying this was a sum that was contractually due to the fund, which of course was not contested by the defendants. They said in evidence, well, we knew this was the fund's money, but we also knew it was going to Fimmel, and Mutah's was the fund. So might I show you some...
Just out of interest, is the deed of release in the papers somewhere?
The deed of release?
The document which was signed in order to enable Reading to pay the missing funds.
We think it's somewhere...
We can't read it in the locations. If your lordship wants it, we'll produce it overnight.
So my submission is the judge didn't really we looked at the start at Robin Airlines in town, and I drew your lordship's attention to the point that it says you need to investigate all relevant factual inquiries, and of course that must be right. What the judge has done is simply to say, well, the money is due to the fund, and almost that's the end of the inquiry. He doesn't expand it further and say, well, what did they believe would happen to it? What authority did they believe details had? And in fact, this was a point that was expressly put in the defendant's closing at trial. The reference is S621, we don't need to go there, but they even said, if, for example, the individual defendants wrongly believe Mutaz to have authority for the fund, it's irrelevant to the honesty of their actions whether they can show that Mutaz had implied or actual authority. All that would be relevant is the honesty of the belief. And I just want to show you some examples of the evidence that they gave. And this is in the unagreed documents bundle, some of the cross-examination.
It might be helpful if we're going to be looking at this to be shown what exactly was the dishonesty which was put to the defendants in the course of cross-examination.
Yes, well, I hope that will emerge from the
well,
exercise I'm about to show you.
Just alerting you to that's something which we might be interested in. Okay, where do we go?
So page 18. This is so at page 18 of paragraph 55, this is a transcript of the cross-examination of Mr. Diallo.
Sorry, page 18. This is Mrs. Diallo, isn't it? Oh no.
No, that's just the remnant of the heading.
That's just the heading.
Sorry, it doesn't appear
Yes,
on the top, but it is in the...
it's Mr. Diallo. Okay.
And this is, I think, although at the moment I've mostly been talking about Mutaz's authority, since we're going to go through this, there are two elements I'm going to draw to your attention. One is the way the defendants perceived Mutaz's authority, and the other is their belief that the money would inevitably go to FIML if it were paid to the fund. And rather than trawling through this twice, it's probably sensible to do it once and show you all of it. So, on page 59, 55 and 56, the bundle page 18, you can see that at the top of page 55, Mr. Jones is putting the question about break costs and break cost clause and the fact that this might mean that the fund would have to retain certain monies. And Mr. Diallo is saying at line 18, the way I read this seems to be if you do get a repayment which does not give you the entire notional, you would not be holding any, you would be holding any additional cost in reserve. And then his next comment on top of page 56, he says, I'm not a lawyer, but if you get a repayment which does not achieve your full funding back, then you've got costs, so then you keep those costs in reserve. That's how I see that. In other words, you may recall that the payments to FCM London, for example, it stated that we're going to be on a transaction-by-transaction, investment-by-investment basis. And Mr. Diallo is explaining here his understanding that if the capital isn't wholly repaid, then you would not be entitled to keep the costs.
And the document he's asking about is the offering memorandum, is it? So this is all about something in the document.
I'm understanding, yes, the quote is at the top of page 55, I'm sorry, I haven't made that clear, which is if break costs of prepayment fee or premium over principal is or are payable on early repayment or disposal of a loan or investment.
The cross-examination is about what a document means, as far as I can see. Which, no doubt, leads up to a point on honesty or otherwise, but is not itself.
So, the bottom of page 56, you can see Mr. Diallo saying, the way I read it is, let's assume Reading would have paid less than the 21, less than the principal amount that was due, then this termination fee would have been classified in this one, in other words, would have had to be held back. But once you get your full repayment, then the fund hasn't lost out, and I don't think this falls into being a reserve. That's my understanding. So that's Mr. Diallo explaining on break fee costs. This, of course, is in relation to his belief as to what would have happened to the money if paid to the fund. On page 57, you see the A on line 8. The whole offering memorandum is done on the premise of a loan-by-loan deal, and everything is defined as a loan-by-loan. If you look at it, it does say to meet any shortfalls in income received or principal repaid. If you do get a loan that's repaid and the loan doesn't give you 100% back, and there are other costs that you'd be taking as a manager fee, that wouldn't align you with the shareholders. That's my understanding here. So it's when the individual loan doesn't meet its repayment. But of course, the principal of the Reading loan was repaid in full. If I can, and then at page 59, the internal 59, top right-hand side, line 19, he says, I think the administrators also, that's Maples, with the accounting authority of this, they seem to have agreed from the documentation we've seen recently how they classified the excess in that income. So he's referring there to the disclosure we've seen. If we...
So just in the middle of page 59, the question that was asked, the question is, if you receive a termination fee, i.e. the 2.2 million, if it falls within the definition of break costs, which is a matter for the judge, but it's what's been put, it's quite clear it should have stayed in cash reserves and for the lifetime of the fund, because you wouldn't know in advance whether there would be an ability to meet the coupon. So what I think has been suggested in that question is that if you receive a break fee, you've got to hold it in cash reserves for the entire lifetime of the fund, because you might not know whether you could pay a coupon at any particular time over the lifetime of the fund.
Yes, I think that's the point.
That was the point. How does that square with what the fund actually did in 2019?
Well, in 2019, well, precisely. And that's why, no doubt, Mr. Diallo picks up on that in his evidence. But that was 2019. I mean, in fact, of course, the fund is also talking net asset, the quarterly net asset valuation happening. But as we saw, the fund actually paid out the money in mid-June, and the end of the quarter is at the end of June. So the money was received in April and paid out in June within the same quarter. Seemingly, it doesn't seem to have been any quarterly net asset valuation carried out by the fund, nor did the administrator seem to think that such a process had to be gone through. So this, of course, is relevant to, this is a...
That's the answer that's given at 59. That's what he means by that answer.
Yes, that's, I think, what he's referring to. He's referring to the Maples documentation. But he says previously, as we've seen, he's saying, my understanding is it's done on an investment-by-investment basis. So the shortfall was only in relation to the particular investment. If Reading hadn't paid back the principal, they couldn't have taken the break fee. They would have to use it to make up the principal. But that wasn't the position.
Yeah.
Maples seem to have operated on the same basis. Whether a court or a judge or anyone objectively says that's not how it works is part of the background for how you assess how the individual defendants understood what they subjectively believed. It doesn't determine what they subjectively believe. And we can see here that's how Mr. Diallo understands it. So if we look for, on to page 23 of the bundle, and Mr. Jones is putting to Mr. Diallo that he was, by reference to a text message, that he was searching around for a justification for paying this money offshore. And Mr. Diallo argues or explains, and said, this is the top of page 163, he says, I mean, it could be here found an explanation, that's referring to the document, what's said in the document. It's basically me anticipating this chat with Mutaz, where he's 100% going to try and renege and dilute our shares. That's been the overriding theme throughout those Bloomberg chats. You can see it, and when you use the word standing firm, standing your ground, dilution, it's not about taking something that's not yours. It's protecting your rights. It's protecting your position. And then the question is, you told me earlier you had the prior agreement of Mutaz, these exit fees would be paid under your so-called profit share agreement. But now you're saying you didn't have that agreement, but you're looking forward to seeking that agreement and having an argument with him. Is that what I'm to understand? Answer, no, I knew these were profits, 100%. We all agreed they were profits, but in this profit share, especially with the fund, because contractually this is due to the fund, let's say they really admit that's the case, you have Mutaz who sits on the investment advisor, manager and fund, so he's got that overriding control there, and he can just simply, if he wishes to, renege on the profit share. And this is just me reminding myself of what we've agreed in case he does say, for example, let's share it with FMB, that's the placement agent. Then I'll remind him that fees are never to be shared with FMB as we agreed. That's all this text is saying. And in terms of, if you turn to page 27, you'll see on 53, top left-hand page, bottom left. The question is, can you explain to his lordship why, so far as you're aware, there was only one recipient shown on the cancellation notice of the termination fee? Yes, so at this time, this is when we're ratcheting up the pressure with Reading, and we're making formal demand for the loan repayment, and understanding, obviously, that this termination fee is going to be profit. We put FIR there as a placeholder until we agreed with Mutaz where to split those fees. So that was a placeholder. And at the top of page 55, in reference to the profit, the termination fee, he says, we knew it would be paid offshore. That was never in doubt because it was already offshore. This is offshore money. It's the fund that we're dealing with. And about at line 14, he says, we knew this money was profit for us as JV partners. We all understood that, all of us. So you made an assumption that this money would not go to the fund. No, it's not. As I said, we all understood how the fund operated, all of us. There was no doubt to anyone involved here that this termination fee was profit. Because in the redemption on, what's the outstanding amount here of 17 million, you've already got quarterly interest of 8.5%. That's already in excess of the 5%. Just that amount already has excess in there. So that's obviously, he's explaining, the 5% would meet the payment to shareholders. There's already an excess above that. So the termination fee was de facto profit. Putting FIA here was only put as a placeholder until with Mutaz, him and I, decided what to do with it like we always did. And then on page 28, in relation to Mr. Mutaz's authority, the question put to him is to say, at the top of the page, you would have to have the agreement of the fund that the full 2.2 million was properly identified, as you would call it, as excess. We already knew that, all of us. But you would need the agreement of the fund to that. But Mutaz, Mr. Diallo, do you agree you'd need the agreement of the fund to the identification of the excess? Yes, and Mutaz is there to do that. Mutaz is there to do that. That's the agreement. The fund consists of a board of 3 non-exec directors, does it not? That's correct, but one of them, I don't think it's fair to classify him as non-exec. Christopher Lebeau was not involved in transactions. He was a Maples director, so they had a very different mandate. You may recall we saw a little bit of that in the offering memorandum this morning. They were not involved in commercial dealings, and David Whitworth, with all due respect, would have done what Mutaz agreed. So what we needed here was Mutaz's agreement. So his evidence is very clear that Mutaz was the person who had to authorise it. If you look at page 32, the question put to him, this is on line 5, page 122, bottom left-hand page. I'm going to suggest to you the one thing you feared, you plotted and discussed, was a situation in which Mutaz wanted to capture that income, profit, whatever, going through the fund to Fimmel. That was your concern, and there was nothing that had happened up until 19th of June to resolve that concern. And the answer is, I totally agree. He agrees that the concern is that Mutaz is going to dilute it. That consent stays until the payment was made, because Mutaz, as the only director that sits on the advisor, the manager, and the fund, could do anything he wanted at that point in time. The question, you knew perfectly well, had you gone to the board of the fund and told them about the 2.2 million, they would have insisted on it being paid into the fund. Do you agree? No, I mean, as I said, Mr. Lebeau is not even involved. I'm not even sure. When you said the board of the fund here, you're talking about Mutaz and David Whitworth. With all due respect, David will do what Mutaz tells him. Here we agreed with Mutaz. Mutaz was, and you've heard it, I think, even last week, none of them were involved in our fee discussions, none of them. That's a reference to the fact that Mutaz is very private about these.
Is it a transcription error at line 14 and 18 where it says consent rather than concern? And if not, what's the consent? 'Cause I'm not sure. The question is about concern.
I assume that must be, seems logical that that's what that means. Yes, because at the bottom of line 18, the same point, that consent stayed, but there's evidence in the chat, but it's the concern.
So in other words, they were worried until they had the money in their pockets, isn't it?
Yes, that it might go elsewhere. And then at page 123, top right-hand side, line 13, I'm suggesting to you, sorry, this is the question, is I'm suggesting to you in the clearest possible terms, if you told the board of the fund about the 2.2 million termination fee, which was due to the fund contractually, it would have insisted on it being paid to the fund. Well, we did. Mutaz is the board of the fund, and Mutaz is on the board, and he's the main person. And then at page 33, on bottom right-hand side, 132, this is now back to the question of profit and whether it would have been paid to Fimmel. And these are questions by the judge. Do you remember saying that everybody knew that 2.2 million was profit? Yes. Can you explain to me how they could do that sureness, that 2.2 million was profit? Sure, my lord. Basically, the fund is a very specific fund, so the investors, shareholders, only have a participation to their preference dividend, and that preference dividend was mostly set at 5%. So there may be some that had 4%. It's 5% for the sake of argument. Anything above that was just going out of the fund. It was not for the investors anymore. So given Reading was alone earning 8.5%, everybody knew a termination fee on top of your quarterly payment was necessarily profit and excess money. So that's why we said we didn't need any calculation. It was very clear for all of us. Like you might hear in some of our meetings, all they care about is the 5%. Above the 5%, that's no longer their participation. It's no longer the shareholders' participation. So your focus is on the 3.5% headroom and anything above that. So between 5 and 8.5 and anything above that. So the termination fee was even above that 5%. The 8.5% was all included in the loan repayment, so that did go to the fund. The 17 million included that 8.5 up to maturity. So the fact of the fee, regardless of its size, this is the termination fee, would only be profit, whether it's £10 or 10 million. So I think I mentioned that briefly earlier, the fact that there was already headroom above the 5%, which had gone to the fund.
Well, I can see that makes sense if you're looking at this investment in isolation. But I mean, the shareholders' right to 5% is the 5% of the total value of the fund, is it not? It's not the 5% on a ring-fenced basis in relation to each investment. In which case, if you had another investment that was underperforming, then you might need more than 5% on other ones to make good the difference.
Well, that is, of course, logically possible. But his evidence is that he's explaining why he could be so sure in terms of this investment. And we saw earlier, when it was put to him that certain sums should be kept in reserve, he was saying it was all done on an investment-by-investment basis. It's that if the principal of the particular loan wasn't repaid, then the profit would have to stay with the fund. But otherwise, it was all profit.
But am I right, the legal entitlement, I mean, may have been disregarded in practice, but the legal entitlement of the shareholders was to a 5% coupon, as it were, on the entirety of the investment.
On the entirety of their investment, that's my understanding.
Yeah,
yes.
I thought, yes.
So one of the things that the points he's made elsewhere is that the reason why, you may recall the reason why Mutaz and Hussam were so keen to get this loan from Reading repaid is because they wanted to invest it in their Floreat aviation note product, which closed in December 2016, and of course this came late. And so one of the other reasons they give is to say, well, when this money is repaid to the fund, it wasn't just sitting there in a bank account. It immediately was going to a new profit-earning investment. So there was no gap in terms of this particular tranche of money. At page 137, this perhaps deals with a question to do with FCM that was raised earlier. Sorry, this is page 35 of the bundle, 137, top left-hand corner. this is in fact a re-examination question from Mr. Cavender, as you can see on page 136. Following my Lord's hypothetical of the 3.5% not being sufficient, what happened when there are expenses generated by the UK vehicle FCM that need to be discharged? What did the JV partners do to deal with that situation? We simply borrowed money from other Floreat companies. So if you'd allocated initially something as profit, but you needed to deal with an expense in the UK company, how would you deal with that? Well, as I said, we would have simply, because we had a borrowing line from FHL, Floreat Holding, which we could draw money from in a view of repaying with future profits. So I think backs up the submission I made this morning, saying profit tended to be shared out, and there's an understanding that expenses would be dealt with in future. Those are some key
It
points.
looks as if Mr. Jones goes on to ask essentially the same question as my Lord has just put to you at page 137, line 21.
Yes. That I understood the question being at the JV level, not at the fund level. And then in terms of the expenses, and again, a re-examination question from Mr. Cavender is what expenses did the fund have? Very minimal administrative expenses. So the comment in reference to it being JV level is this point about understanding that things were dealt with project by project, as it were. My learned friend says the JV refers to the joint venture profit share agreement, which of course the judge said is not a binding agreement.
Yes.
Looking at Mr.
I'm sorry, I was speaking to the learned friend and not addressing the lordships. The only point I made was that I think he was interpreting my reference to JV level in that question as investment by investment. That's not what that goes to. JV goes to the alleged joint venture included in the profit share agreement. So I'm simply correcting his, and I don't blame him for it, it wasn't the trial. I'm simply correcting his assumption that that was investment by investment question. It wasn't.
Right, thank you.
So we can see, looking at Mr. Nuseibeh's cross-examination, there are some similar points here about authority of Mutaz on the very first page, 161. Line 4, to your knowledge, did the board of the fund agree that you should receive 1.1 million into your company in Cayman? Mutaz did on behalf of the board. There was no agreement between IRL and the fund, nothing in writing. There was a meeting with Mutaz.
Sorry, I've lost you.
I'm sorry,
I've got your reference.
On page 36 of the bundle.
Yeah, sorry.
161, top left-hand side.
Yeah.
This is Mr. Nuseibeh now being cross-examined. And then page 164 at the bottom. Line 16. Well, for practical purposes, I understood what was the reality, which is that Mutaz had an authority to act on behalf of the fund and agree the way this money will get distributed. And I think Oumar explained in quite a bit of detail, which again, he's typically the guy who deals with it, as how that process happened. So he's being asked questions about, did you understand that you must have understood there to be a contract between IRL and the fund? And he's saying, well, practically, this is what happened. Mutaz was in charge of it. On the next page, page 37 of the bundle, page 167 of the transcript, top right-hand corner. The question, can I ask why you simply didn't, in your capacity as an employee of FCM, write a memo to the fund, to the board of the fund, saying we've got a termination fee of 2.2 million coming in, we'd like 1.1 transferred to our bank account in Cayman, is that okay? Can you explain why that wasn't done? Well, I've never, so let me make a distinction. I've never written a memo to the GFI board, but it's essentially, again for practical purposes, Mutaz sat essentially as our boss and the investment advisor, and he sat as the FIML director who supervised our work, and he sat representing the fund. So I don't know what you mean by writing to the board. You know, I suppose if Mutaz instructed me to do that, I would have done it, but there was no need to do it. And then the bottom of 168, similarly. Mr. Jones says, here we see nothing by way of a contract entitling you to this money, and it's that difference I'm trying to explore with you and ask you why not. Again, probably the more appropriate people to address that to is Mutaz, because he ran the show, is the way I looked at it, as an employee within FCM. At page 41 of the bundle, page 80 of the transcript, bottom right-hand side, and page 79, in fact, let's start at line 15. The question is, so the money that's intended to go to the fund, which the fund had an absolute right, you're trying to work out ways of avoiding that to benefit yourself, correct? I'm trying to find ways to ensure the profit share agreement is respected. If the money goes to the fund will do what the fund wishes to do with it. So the only way you can ensure your profit share is equal to expected is to find some way of ensuring the money did not go to the fund. Do you agree? No, the fund obviously, the structure couldn't do anything with that money. It had to be paid up to FIML. And the concern is the one I've just outlined, which is if it does go there, there's a possibility you might end up dividing it not the right 50-50, but 25-75. So the concern is not that the fund will take it. The concern is that it will go to FIML, where Mutaz will have control of it. Page 43 of the bundle, page 96, bottom right-hand corner of the transcript. Question, when you talk about a mandate, that's normally something you'd expect to see in writing from a board of directors. You're not indicating the board of the fund at any stage had mandated you in that way. The mandate was by Mutaz. There's many, many things which are not on paper in this setup. We were going through many things. And that's a judge, of course, made a passing comment to the effect that matters in the Floreat structure were not always done by the book. It doesn't quite use that phrase, but that's the gist of it. Then on page 44, internal page 112, at the bottom right-hand side, this is still Mr. Nuseibeh, line 13. Said, the idea was exactly what I explained earlier. With regards to us considering the termination fee or any part of it would necessarily be excess profit and will not be for the fund's benefit. And so on that basis, it's consistent with what I communicated with them in December, that they will need to be paid into a separate account. So that's talking why the termination fee was paid to a separate account from the principal. Question, you see you had not at this stage asked the fund whether this money was excess, had you? I think that understanding is something we had right from the start.
So what's the document they're looking at here?
Sorry, this they're looking at I think it's the draft termination notice. And he's being asked by the instructed the fund's solicitors, Burgess Salmon, to amend it to remove some additional words.
This is the agreement I asked about. So I thought it was called a release agreement, but maybe it's not.
I don't think this is the release agreement. I think it's the cancellation notice or termination notice, which I think there's an amendment to it. Perhaps I should check that and be clear.
Well, it's an updated draft signed by somebody on behalf of the note holder. And there's a reference to a second draft of the agreement. The note holder is presumably the fund, yes.
Yes.
And so this suggestion is this is the agreement between Reading and the fund. Is that right? presumably in relation to the termination of the arrangement, the loan. Is that it?
I think that must be right, but I'm afraid I can't immediately
Right, that's-
identify
Well, may I
the
help?
relevant document.
I'm not able to remember with any clarity because I certainly haven't come to this appeal on the basis that it was going to be a deep dive in the entirety of the transcript. And these, as you know, are documents we don't think should be forwarded. But if your lordship goes back a page to 43, I think
They're not continuous.
no, they're not continuous pages.
And I don't think
Well,
that's...
I was referring
Hannah.
there to C5123. No, I don't think it is the same. Then it may be the cancellation notice is always going to help with, but I can't be. I'd have to go back over the entirety of the transcript here and the trial bundle to find out what these documents are.
Yes, right.
But
It is. Yeah, we think it is the cancellation notice.
Yes, and that seems to be, again, if you look on page 113, on big page 45, top left-hand corner, you're drafting a formal demand. It's called a cancellation notice, but it is a formal demand on behalf of the fund. And that seems to be a reference to the document we're talking about.
I think so.
So this is Mr. Nuseibeh dealing with the fund's lawyers,
Yes, with Burgess Salmon.
with Burgess Salmon, over the... So the lawyers were heavily involved in...
The lawyers were involved in, they were the fund's lawyers with respect to the redemption of the Reading loan, which FCM London was
Yeah.
given authority to deal with them in relation to that. I've taken you through some of this. Perhaps I've shown you enough, certainly from Mr. Diallo and Mr. Nuseibeh. I can give you other references, but my point is that, as you have seen, there's very extensive evidence from the individual defendants that shows that they repeatedly gave evidence that they understood that this was excess. They understood that Mutaz was the fund. And so if, in my submission, one looks at the finding that the judge actually made and say, well, this simply wasn't the right finding in terms of what their subjective belief was. He didn't make a finding properly as to whether they understood that Mutaz had authority to deal with the termination fee in the way that he did, which is very different from whether he had authority simply to appropriate the entirety of the fund, as it seems, for his own purposes. There are a couple of other points in relation to Mutaz's authority. And one is that Mutaz himself...
So, sorry, I'm going to come back to this. At page 112, in the middle of the page, the questioning is on the basis that Mr. Nuseibeh was persuading the lawyers, the fund's lawyers, to change the agreement so that the fee would not be payable to the fund. And his answer was, well, yes, exactly, because this was... The termination fee, only part of it would necessarily be excess profit. It won't be for the fund's benefit, and so, etc. So, putting aside anything else for a moment, it's the fund's lawyers are involved in a change of the agreement they've drafted to prescribe that the termination fee will not go into a bank account of the fund, but will go to some other bank accounts. Which is why, presumably, when they were then given the instruction that we saw a little earlier,
Yes.
It all, from their point of view,
It all made sense. It all added up. I assume so. I wouldn't like to speculate as to exactly what Burgess Salmon thought. But yes, they had been involved in this redemption.
Well, that's what I said to you earlier. There must have been something that preceded that email, because otherwise, if it just came out of the blue, any sane solicitor would say, well, sorry, what?
Well, yes, I'm sorry if I've not answered that very well. Yes, they had been involved in previously in the redemption. There were negotiations throughout this period as well with Reading about threats to force.
Yes, but also specifically about the destination of the funds, and some questioning put on the basis that an earlier draft had said that the money would go into the funds account, and in a discussion with the lawyers, it was agreed, is this right, that the fee would then go to some other accounts. That's in a discussion with the fund's own lawyers.
That seems to be what's going on there, and the notice gets amended.
Okay. Right.
I was taking you to how Mutaz saw his own authority, indeed how the judge found that Mutaz saw his own authority, which is at paragraph 128 of the judgment.
Have we finished with the transcripts in the unagreed bundle?
I think we have for the time being, thank you.
Thank you very much. 1 to 8, did you say?
Yes, paragraph 1 to 8 of the judgment. So, in fact, starting a little earlier, one sees at 124, in these circumstances, Mutaz, on behalf of FIML, in its capacity as investment manager, gave instructions to the individual defendants on behalf of FCM London to achieve early repayment, and in that effort to ignore recovery of fees to which the fund might be entitled. These are the instructions, which is the basis on which the judge found against the claimant in relation to the prepayment fees and the alleged missing termination fee. Mr. Mutaz Taibi's authority, this is paragraph 125, Mutaz's authority for FIML and the fund amply extended to giving the instructions. And complying with the instructions, Mr. Nuseibeh, working with Mr. Diallo and Mr. Churchill, undertook the necessary negotiation with Reading FC and its shareholders. It's no surprise to find the fund itself suggesting that FIML had delegated its duties to manage the redemption of the financing to Mr. Churchill, Mr. Diallo and Mr. Nuseibeh. It was the fund's case that only the full board of the fund had authority to waive or fail to exercise any contractual obligation owed or potentially owed to it. I respectfully but completely reject this. The task of managing the fund's portfolio of assets would obviously require decisions of this very nature. They fell amply within clause 3.1 of the investment management agreement, by which FIML would take all day-to-day decisions about as FIML deems appropriate in relation to the management of the portfolio, and would do so without prior reference to the fund. 128. At one point in his cross-examination, Mr. Mutaz Taibi was shown a reference to his going so far as saying, "I'm the fund." He sought to explain this as having been said in the heat of the moment, but in my judgment, what he said was the way he saw things. Of course, Mutaz's authority for the fund and FIML was not without limit, and then this finding, which gets repeated later, it did not allow him to treat assets of the fund as his own to apply to his advantage or give away for his own purposes. But that limit did not prevent him giving instructions that authorised compromise or concession where that was in the interest of the fund. The instructions were of this nature. Now, that finding by the judge is, I think, based on evidence that Mutaz gave in subsequent employment tribunal proceedings, which transcript of which was before the court. And we can see this at bundle S255A, which I hope has been inserted in the right place. If not, it's possible it's found its way right at the back of bundle 2, but I hope it's in the right place.
Or is this S1 or S2? Is it?
In my bundle, it's S1, it's tab 23.
Yeah. Thank you.
255A.
And these are proceedings by whom against whom?
These were employment tribunal proceedings brought by the individual defendants for constructive dismissal against FCM London.
Sorry, tab 23, was that?
Yes.
I've got a transcript from some. Oh, I mean, sorry, yes, I see it, isn't it? Employment. Yes.
I think this was originally missing, which is why it's an insert.
Yes, I have got it. 255A and B, yes, they are. Okay, yeah,
So if one looks at 255 itself, he gets asked, and this is Mooshouse giving evidence, he gets asked a question by the employment judge. When did you terminate the investment advisory agreement before that meeting? Again, to find a way out. And just Mooshouse is giving some background on the fund. It's at line 7 of page 100, bottom right-hand page. In March 2018, I decided to establish 2 companies. This firm, Floreat Investment Management Limited, was set up by myself in 2015. I own it 100%. To own the management shares in a fund called Floreat Principal Investing Fund, to run a private equity fund. 3 months later, I created another fund called Global Fixed Income Fund 1, that is this fund, which FCM was the advisor on. It's owned and controlled by FIML. At page 101, line 11, this is a point we'll come on to, but again, this is Mooshouse saying, FCM, the issue with FCM is a clash of characters between me, my other partners, and the 3 claimants. It was obvious to them in the court, I'm a difficult person, I cannot be managed. And then on the right-hand side, page 103, at line 5, he's asked a question, when you were asked by Mr. Nuseibeh in the board meeting why the advisory agreement had been terminated, why did you not provide the explanation you've now given? And he proceeds to say, he didn't ask me why, I was in the meeting and I recall Mr. Nuseibeh had no pen or paper to remember. He can't remember what he wrote in his claim in this tribunal to remember what I said. In that meeting, Mr. Nuseibeh said to me, you terminated that agreement, and he looked me in the eye and said, because you control it, you control it. He wanted me to admit, of course, this is my company, I control the fund, I control the investment management, and I'm 50% of the investment advisor. That's known. So we see Mooshouse's own evidence, where he is only one of 3 directors of the fund. Technically, of course, he doesn't control it. But that's certainly how he saw things. And the judge made the finding at 128 that he, on another occasion, went so far as saying, I'm the fund. So if, since it seems from Mooshouse's evidence, if he subjectively believed that he was the fund, in my submission, it's a very strong foundation for saying that the individual defendants' belief, as expressed in their cross-examination, in their evidence, that Moosehouse was the fund, is reasonable. It's very likely to be true. So I would just give you a few, because I'm conscious of the time, I'd like to give you a few references in terms of where the witnesses say that the witnesses' evidence as to Moosehouse being the fund, controlling the fund. We've looked at some of the cross-examination of Mr. Diallo and Mr. Nuseibeh. Also appears at paragraphs 23 and 32 of Mr. Diallo's witness statement. That's at S286. Mr. Nuseibeh addresses it at paragraph 45 and 106. That's at S318 and S336. Mr. Churchill addresses it at, in his witness statement, paragraph 23, 27 and 64. That's S261, 263 and 275. And there's also a brief point by Mr. Churchill on this matter in the transcript of cross-examination at U62. So Moosehouse himself seems to have said, I'm the fund. He reckoned that he was the fund and could control it. And this was the evidence that the individual defendants gave. And in my submission, if the judge is going to make a positive finding that the individual defendants did not have the belief that Moosehouse was able to control the fund, at least to the extent of giving this termination fee, he would have had to have been more specific and given some proper reasons for it. Bear in mind that from the perspective of the individual defendants, all the fees from this project, given that the principal is being repaid in full, were coming to them. So the judge has found that 2 sets of fees the advance prepayment fee, the missing termination fee payment, Mutaz had ample authority to waive. And yet, this other fee, which would also be going to them, ultimately, so they thought, he so obviously didn't have authority to waive it that the judge considered that the individual defendants were dishonest. In my submission, it's not, the judge's finding doesn't seek the right findings. He doesn't really make the right.
Would it be right to say at this stage of your submissions that really it's FIML rather than the fund we need to primarily look at? Because, as I think one of the answers you were taking us to pointed out, the making and calling in of investments is one of the matters which is delegated to FIML. And FIML really is, on any view, Mr. Nuseibeh, because he's the sole shareholder and the sole director.
This claim is, of course, I mean, the judge refers to the claimant as the fund because it's brought by assignment. So essentially, the claim is brought by the fund. So once the money reaches FIML, if I can put it that way,
yes,
then as far as the fund's concerned, it should make no difference. There's then no loss, it's got no claim, it has no further interest in that money. But you're absolutely right, which is once it goes to FIML, the judge found he was the sole executive director, though there were others. He was the sole shareholder, crucially. So once, in my submission, once it gets to FIML, if I can put it that way, then there can be no legitimate complaint in the mind of the fund as to what Mutaz then decides to do with it.
No. And it's not just at the stage of when the money reaches FIML, but it's the stage of actually calling in the loan in the first place, because that is something within the delegated authority.
Ultimately, the investment manager who makes the decision. Absolutely. So, I think I mentioned earlier, if the defendants and Mutaz thought that this was an improper dealing with the termination fee, they, in my submission, wouldn't have gone about dealing with this in the way that they did. And some examples of that are, if you look at J186, so that's paragraph 186 of the judgment.
So that page 186 or
I'm sorry,
paragraph?
page 152, paragraph 186 of the judgment. This is the draft deed of release. My lord, this may answer some of your questions about the involvement of Burgess Salmon as well. So in 177, in December 2016, Mr. Nuseibeh had instructed Burgess Salmon termination or restructuring fees to be paid by Reading was to be paid to another Floreat entity rather than the fund. The amount of the fee at that time was 600,000. You may recall the fee was substantially lower because they were very keen to get the loan repaid before the aviation note closed on the 21st of December. So at that point, they're prepared to offer a much greater discount. At 183, you'll see the judge found that I'm not satisfied that Mr. Nuseibeh or Mr. Diallo handled the draft deed of release, in a way that deliberately sought to avoid Mr. Mutaz Otaibi being alerted to its content. So this is the, I'm sorry, I'm doing this out of order. The paragraph 180, if we go back a little, you'll see the judgment refers to a draft deed of release was prepared. It referred to a termination fee. Mr. Nuseibeh printed a copy in order to show it to Mutaz. However, Mr. Nuseibeh agreed with Mr. Diallo that he should avoid getting drawn into a discussion with Mutaz about what should happen to the fee once paid, and should just obtain approval for the document. So it was a draft deed that showed a separate sum as a termination fee, but it didn't say what it was at that point. And then at 185, 184 and 185, I just invite you to read, as it may help to explain some of the background of the involvement of Burgess Salmon. And also 186, saying Mr. Nuseibeh sent a draft deed of release to Mr. Whitwell for signature. It was undated, and the outstanding principal to be repaid was left blank, as was the termination fees to be paid. Now, of course, if once the scene had shifted from the judge's perspective, and he had decided that Mutaz knew all about this payment, then if there really was some kind of wrongdoing cooked up between Mutaz and the individual defendants, they wouldn't involve Mr. Whitworth. The premise is that the individual defendants were seeking to conceal this from the board of the fund, which only left Mr. Whitworth and Mr. LeBeau, and Mr. LeBeau had very limited involvement. So that's one way in which it doesn't sit right with the idea that they thought, or subjectively believed at least, that they were doing anything wrong. The next point, of course, is that the monies were paid to two companies, FCM Cayman and IRL, of which Mr. Whitworth was a director. We saw that in opening. Now, Mr. Whitworth at the time was the sole director of FCM Cayman and the sole director of IRL. His evidence was that he did not have access to the company's bank accounts. But in March 2017, and for this, could I please invite you to take the unagreed documents bundle again, and look at Mr. Whitworth's witness statement for trial. Paragraph 41. Says...
Sorry, reference again, sorry.
I'm sorry, with the unagreed documents bundle. Tab 1.
Paragraph 41.
Paragraph 41 is where he says, I signed FIR, that's IRL now, that used to be Floreat Investment Relations, where he says, I did not have rights of access to the accounts and did not have visibility over payments as they came in or out. But if we then move on to paragraph 71 at page 13. So at this point, Mr. Whitworth's talking about paragraph 70. I liaised with Mr. Diallo in March 2017. That's before these payments were made. On a board resolution for FIRL that would document projected income arising from its liaison management agreement with FFISA on FAN 1, that's the aviation note, and the payment out of an ongoing quarterly dividend to ultimate beneficial owners. The board resolution I agreed with Mr. Diallo noted FIRL's income from the liaison management agreement and provided that ongoing quarterly dividends be paid to the ultimate beneficial owners, so that's the three defendants, individual defendants, with 4 provisos, including that FIRL's director be provided with electronic copies of bank statements on a quarterly basis in arrears, in addition to other forms of reporting. Well, that, of course, is Mr. Whitworth himself. So in March 2017, Mr. Diallo agrees with Mr. Whitworth that to facilitate the payment of dividends, he will provide him with bank statements on a quarterly basis. And then, if you turn please to page 15 and paragraph 89, you will see that Mr. Whitworth says, on the 24th of January 2018, Mr. Diallo emailed me from his Floreat email address, FIRL's bank statements at EFG Bank for the period 1st of January to 31st of December 2017. Paragraph 94, I believe I briefly looked at the statements, but I do not believe I looked at them in detail. I believe I probably just focused on the closing balance, noting that it's in credit. I didn't notice that the US 1.099 credit related to the RFC transaction. So the situation is, with this particular supposed fraud, is that the monies which were supposedly being concealed by Mutaz and the individual defendants from the board of the fund, which Mr. Whitworth is a member, were sent to 2 companies of which he was a director. Now, even if you say that they would have known he didn't have access to the bank accounts, that seems like a very strange and high-risk thing to do, to put the monies notionally under his control. And even stranger for Mr. Diallo to have reached a specific agreement that he would provide him with bank statements only 2 or 3 months beforehand, and then actually to send him the bank statements afterwards, in which this particular payment was shown. So I think that is those are my submissions on Mutaz's authority. I have just a couple more points in relation to
Well,
the...
and Mr. Whitworth is of the view that the payments to Mutaz's company was an error.
Well, that's
Apparently.
how the board memorandum was subsequently drawn up.
Which he signed.
So that's who drafted it or who was responsible for the wording, I obviously can't say. But
He signed it.
So in terms of reverting now to, so that, as it were, is the first subjective belief. I say the judge didn't make a proper finding as to whether the individual defendants subjectively believed that Mutaz had authority to deal with the termination of the payment in the way that he did. And I've showed you their evidence. I've showed you how the judge found that Mutaz saw himself. And I've made some points about the rather inept way, put it this way, that they must have gone about this supposed fraud if they really were trying to conceal it from Mr. Whitworth. In terms of the second belief, so the belief that the money would have been paid to Fimmel, in my submission, the judge should have addressed the question in terms whether the individual defendants believe that the diversion of the termination fee away from the fund would necessarily cause it and its investors no loss, as it would inevitably be paid by the fund to Fimmel as excess. And as we've seen, the judge adopted a very narrow approach to findings and reiterated that because the individual defendants knew that the money was contractually due to the fund, that was enough. And I think your lordships are with me that we saw in on authority, and as it is in any event, I would say obvious. One has to take a broad view of the relevant factual circumstances. One can't simply take an extremely narrow view and say, well, this money is due to the fund and that's enough. I mean, just to take a very simple example, if in circumstances of set-off, for example, if principal owes an agent £100 immediately and hasn't paid, and the agent collects £50, which is unquestionably due to the principal, and then sets it off, it wouldn't be dishonest to say, well, I'm taking a very narrow view and say this £50 is undoubtedly due to the principal, and the agent knows it, and the fact that the agent then keeps it means that it's dishonest. I don't think that wouldn't be a fair way of approaching that question. It wouldn't be something that would be seen as objectively dishonest. So the real issue of honesty in the context of this belief as to what would happen with the money is not to do with the contractual mechanics so much as did the defendants, individual defendants, subjectively believe that the fund would lose out? And the answer to that is no. We've been through some of the evidence. I don't propose to take you through any more, which just shows how each of them, in oral evidence, dealt with the question. I could take you to the written witness statements, but would you like me to do that, or would it be more helpful just to give you references?
What's the references, I think?
So in terms of Mr. Diallo, his evidence that he believed that the termination fee if paid to the fund would definitely be paid out to Fimmel as excess, he deals with that at paragraphs 82, 90 and 96. That's S302 to S307. And in the oral evidence we've seen some of that. Mr. Nuseibeh deals with this in his witness statement at paragraph 90 at S330. Mr. Churchill deals with it in his witness statement at paragraphs 59 to 60, S273, and also again in extracts of oral evidence at U60 and U61. And this brings us back to what happened to the money in 2019 that was repaid by FCM Cayman to the fund. And as I think we discussed earlier, in my submission, the judge didn't really deal with that evidence fairly, because he simply said, well, I don't accept that's what would have happened. He didn't do so by reference to challenging documents, and of course the documents included the fund's own accounts, it included the memorandum from the administrator, it included the director's own written resolution. He didn't say that the documents weren't right. He just said, well, without a full investigation of the underlying facts. I can't accept that that's necessarily what would have happened. But of course, in terms of what the individual defendants actually believed, he didn't need to make the finding that absolutely it definitely would have been paid. And what that evidence shows, in my submission, the fact that the administrator subsequently paid it to the FIML in exactly the way that the individual defendants had said would have happened at the time, is strong supporting evidence, not just that it would actually have happened, but certainly strong supporting evidence supporting their belief that it would have happened. So in those two respects, in my submission, the judge didn't go about the finding of dishonesty the right way. He didn't really focus on the right question when asking himself what the individual defendants subjectively believed. And certainly in light of the evidence they produced, didn't provide sufficient reasons to explain why he rejected their evidence, which was given repeatedly and cogently in those two respects. And of course, having, in my submission, asked himself the wrong question in terms of subjective belief, then the question of objective dishonesty was also seriously flawed. He should have found that by the standards of ordinary decent people, it was not dishonest, even if it was inappropriate, to shortcut the contractual structure in the way that happened. Ordinary decent people would be asking the question, well, did they honestly believe that the fund would lose out? They honestly believed that the fund wouldn't lose out, and they honestly believed that Mootaz was the fund, and he could authorise the payment that would reach FIML anyway in this way.
Is it a part of that, and if so, is it a necessary part that they believed that if it was left to trickle down, as the expression was, that Mootaz might dilute it?
I think that their concern that Mootaz or anybody might interfere with FIML's contractual right to obtain the money, in my submission, is not relevant to, or at least does not, certainly does not support a finding of dishonesty. Because if they were simply concerned that somebody might misappropriate the money along the way, you might say, well, it wouldn't be dishonest if you took steps to ensure that the money wasn't misappropriated and instead it went where it should have done. The fact that they were concerned that somebody might take it doesn't impact on their belief as to where it should have gone. It's the fact that FIML was entitled to it. They said it was bound to go to FIML. And in my submission, when you see them giving evidence in that way, they're talking about the structure and the money that was available and the fact that it was all profit. They're not specifically saying, I'm absolutely certain that the directors wouldn't fall ill and they wouldn't be able to sign off the relevant payment or anything of that sort. They're concerned that Mootaz will take the money, but in fact their concern, as we saw in Mr. Nuseibeh's evidence just now, is not even that Mootaz will take the money from the fund, it's that Mootaz will take the money once it gets to FIML. And by take the money, of course, I use this very broadly, meaning he will find a way to dilute them, he will find a way to pay fees to Floreat merchant banking, rather than in the way that the individual defendants thought should have happened. And of course, as was agreed, that the profit was effectively split 50-50 between the two competing groups.
As I understand it, your argument is that to forestall that possibility that they feared, they reached an agreement with Mr. Mootaz as to how the money should be remitted to the two offshore companies.
Yes, they reached an agreement. They reached an agreement in advance, essentially to avoid it falling into his hands, because once it fell into his hands, he would, as it were, be in a stronger position to misappropriate it. At the point where they reached this agreement, it still hadn't even been paid out by Burgess Salmon.
Yeah, but they thought that, as I understand it, your argument is that they were concerned that if Mr. Mutaz, if the money was paid to Fimmel, where it would fall within the control of Mr. Mutaz, he would find ways of diluting what ultimately might pass to them via the onshore route via FCM if it ever went that route. So,
or via an offshore route.
But so they, as I understand it, the point is that the judge found that Mr. Mutaz was well aware and consented to. Is that right?
Yes, he gave informed consent to the process.
To the process, which involved them telling the fund's solicitors to make payments to the two companies, to FCM Cayman and IRL, which they did.
Yes, he didn't make a specific finding as to that, but he did say he agreed to the diversion of the fee on a fully informed basis. So following the meeting between Mr. Nuseibeh and Mr. Diallo and Mutaz on the 19th of June, I think it's that same day Mr. Nuseibeh goes off and sent that email we saw saying, please pay the funds in this way.
Oh, again, and you say in the belief that this would inevitably find its way down the contractually agreed chain in any event, and Mutaz was able to agree that it shouldn't.
He was able to say it's on the footing that the money would go to Fimmel, and once the money was in Fimmel, first of all, the fund is no longer interested in it; it's not suffered any loss.
Yeah. And
secondly, as my lord pointed out earlier, Mutaz was held by the judge to be the sole executive director of Fimmel. He owned all the shares in Fimmel. Fimmel then owned all the voting shares in the fund as well, as opposed to the investors who had the non-management shares. I'd just make some submissions in relation to knowing receipt. I mean, in a sense, it closely follows on from the finding of dishonest assistance. Except there's a further point, which is at J462, and so it's 462 of the judgment. Liability on the basis of knowing receipt. And at 464, the fund invites the findings that Churchill finding 31.2, the individual defendants and FIR had sufficient knowledge, given their knowledge that the diverted sum was contractually due to the fund, and their actual constructive knowledge of the terms of the offering memorandum, that their receipt of those sums were referable to breaches of fiduciary duty, such that it is unconscionable for them to retain the benefit of that receipt. And the judge simply says at 465, I'm able to make that finding. Well, the danger of proceeding by reference to these very broad brush findings put forward by the claimant is that the allegation is that those sums were referable to breaches of fiduciary duty without actually saying what fiduciary duty was that has been breached, or even who breached the fiduciary duty. And without knowing exactly what fiduciary duty is being referenced, it's very difficult to see how you can then reach the further finding that they knew that the fiduciary duty had been breached, because we haven't yet established the factual basis on which their knowledge is predicated. Now, this is also at the same finding. It's made worse by the fact that the judge doesn't just says I can make the finding, but doesn't give reasons for it. And then if we look at what fiduciary duties, if one is assuming, let's assume for the sake of argument, that these are predicated on, say, Fimmel's duties, we just have a look at how those duties are put in the particulars of claim. That's C232.
Just before you go there, there's a you're going to come back to what the actual or constructive knowledge of the terms of the offering memorandum referred to.
Well, I mean, it's a similar point, but perhaps that they need to specify exactly what it really flows into which fiduciary duty is being breached. They need to say, well, what is it?
Has the judge identified somewhere else the basis for saying that there was actual constructive knowledge of the terms of the offering memorandum, and if so, which?
Well, he makes various findings. I mean, he says, paragraph 57, for example, page 127. He says, I was satisfied at the trial that Mr. Churchill, Mr. Diallo, and Mr. Nuseibeh were at all material times familiar with the offering memorandum. That's one that immediately springs to mind. There are other findings in relation to matters that are in the offering memorandum. I would have to track them down for you. My learned friend perhaps will no doubt point them out to you tomorrow. But even in my submission, even that, there's no clarity on what's being referred to there. But that's even a subset of lack of clarity in terms of the lack of clarity as to which fiduciary duties have been breached and how it is said that they therefore know that they've been breached. And of course, the point again about the terms of this finding is that the finding is in terms of their actual or constructive knowledge. Now, if it's only their constructive knowledge, there's no analysis of various 5 categories of knowledge and as to whether it's relevant knowledge which is sufficient to found a finding of knowledge for the purposes of knowing receipt, or whether it's merely some kind of constructive knowledge, not knowledge they actually had, not the type of knowledge that affected their consciences at all.
Well, normally constructive knowledge is knowledge which you would discover in the ordinary course of conducting a transaction, isn't it? Like it's a conveyancing type of knowledge.
Well,
in other words,
I mean, with
well, okay, you tell. It may not be your, maybe not your. You can perfectly well say I don't know. So if you want to say I don't know, then don't answer. But because it may, you don't have to explain this. It may well be for Mr. Jones to explain. But I'm interested just to know what species of constructive knowledge.
Well,
is
in my understanding, constructive
there.
Knowledge could cover a wide range from blind eye knowledge, where there would be some implication of your conscience being affected, to something which was pure negligence. It simply failed to read something, which might mean that your conscience wouldn't be affected.
Well, I think constructive knowledge is knowledge which you would have obtained if you had done that which was ordinary in the course of a conveyancing transaction, I think, from memory. It comes from conveyancing type transactions.
Well,
anyway, but okay, I may be completely wrong about that, but it's knowledge which you would have gained if you'd have done what an ordinary person in some conveyancing transaction would do.
But even if that's right, I'm afraid I'm not in a position
and it may be wrong,
to comment on that. But even if that's right, that would mean it was knowledge that constructive knowledge might mean simply that you'd be negligent. There's no necessary finding.
The whole point. Sorry, I'm being very obtuse, perhaps. The whole point about constructive knowledge is it's not knowledge that you actually know.
Yes.
It's not subjectively in your mind. It's something which is attributed to you by a process of law. So if you're inquiring into what you subjectively know as a basis for deciding whether it's dishonest or not, something which you're only constructively held to know is something which you don't actually have in your head.
So that's certainly true in terms of dishonesty. I was just approaching it slightly differently because here, of course, we're talking about knowing receipt.
But then there's the discussion. Perhaps that's your point about the 5 species of knowledge in Baden Delvaux, because it's a question of unconscionability.
Exactly, and so
it's either what you know or what you would have known if you'd have done what you.
Of those species of knowledge, some might impose liability and some might not. And my point is, it's certainly because it's put in terms of actual or constructive knowledge. There's no reasoning in the judge's finding. There's no necessary finding of actual knowledge. That's certainly true. It's not clear what the constructive knowledge is. It's not clear what the breaches of fiduciary duty is said to be. And there's no reasoning of primary facts as to the defendant's knowledge, certainly at this point, although... But really, if the judge is finding that my clients are liable for knowing receipt, it ought to be possible to read the judgment in the section on knowing receipt and identify what it is, which fiduciary duty has been breached, and what it is they're said to know and why. And essentially, by making the findings in this way, we're being asked to trawl through the judgments and see if there might be other findings which might be consistent with what the judge has found, rather than actually looking at the judge's finding and saying this can stand on its own 2 feet.
I'm surely with any issue of dishonesty or unconscionability, which is much the same thing under a different label, I mean, the normal starting place surely is the pleadings. And you have to see what it is, what is the nature of the dishonesty which has been alleged. And I think if we do that, we're going to find a lot of it is related to matters which were not found in the claimant's favour at trial.
Yes, I mean, I can show you the pleadings, and part of the difficulty is that they're pleaded in such a broad brush way.
Yeah.
It says, by reason of dishonesty at, let me find it, paragraphs 28 to 99 above. So this is in bundle C, page 273. And it's the heading dishonest assistance at the bottom of that page. I don't know if you have it.
Yes.
FIML owed fiduciary duties to the fund in respect to the actions of FCM and individual defendants. So that's an allegation about FIML owing duties. Then paragraph 110, FCM also owed fiduciary duties, according to the pleading. And then 111, by the individual defendant's dishonest actions in using FCM as a vehicle through which to procure the diversion of the diverted sum, assuming what it seeks to prove, which they knew was properly due to the fund, their corporate entity IRA, as set out at paragraphs 28 to 99 above. The individual defendants procured that FIML and FCM both, through their agents but without the knowledge or participation of their boards of directors as a whole, breached their fiduciary duties to the fund. Now, we know that the judge, of course, found that Mutaz knew all about this, and since only Mutaz and Mr. Diallo were directors of FCM, they presumably can't stand up as regards FCM. And then at 113, you see the individual defendants dishonestly assisted FIML's and FTM to breach the fiduciary duty to the fund, and they're thereby liable to account.
Is there anything in paragraphs 28 to 99 which expressly says this was dishonest or anything like that?
I have not searched for the particular word. I mean, that is what sets out the entire background.
Yes, well, it just says,
Background
I haven't
scheme.
read it all, but it says what happened.
It says what's happened, so I would hesitate to say that it doesn't allege it directly, but it seems to be that if you're going to make a finding of dishonesty or knowledge sufficient to fix you with obligations to repay large sums of money, then with a pleading which refers to a great swathe of particulars of claim, the judge ought to have engaged with it and said, well, what fiduciary duty has been breached? What is the relevant fiduciary duty? What was their knowledge? What was their actual knowledge? Which is being put together in such a way as to affect their consciences. But the claimants have pleaded it in this very broad brush way, and even the finding that they sought, as we've looked at, was pleaded in a pretty broad brush way. And no doubt they expected the judge would start with their finding and go on to make a reasoned conclusion, but that's not what happened. And so what we're left with is a very unsatisfactory finding by the judge, which is very hard to see what his reasoning is. It's hard even to see what the basis of the finding is.
Well, the problem is that, the suggested finding is really a suggested conclusion, which the judge is being asked to reach, and there's nothing wrong with that, as long as the judge doesn't do it back to front and just start with the conclusion and say, yes, that's fine by me. I think.
Well, that is,
instead
course,
of analysing the thing from first principles and going through the evidence to establish whether all the ingredients of the cause of action are made out.
well, your lordship is very much ahead of me in terms of what we call our general ground of appeal, which is that may be a reason why judgment has been written in the way it has been, which is it suggests, come on to this, but we suggest that the fact that the judgment was disrupted in its preparation, it was delayed, means that, as you say, rather than saying, well, what's the elements of the cause of action, the judge setting out for himself what findings he was prepared to make from first principles, as it were, he simply accepted the invitation of the claimants to make certain findings, but which, with the risks that are concomitant, because without giving adequate reasons, and without really picking apart the findings, it's hard to see what the judge has really found. Sometimes, of course, the judge does pick apart the findings. I showed you earlier points at which findings are encouraged to say that the individual defendants were liable or were instructed to do something rather than FCM London, and the judge meticulously goes through and checks that every time. But in a case such as at this point, in relation to knowing receipt, that's just not something that he does.
I mean, the basic principle, obviously very well known, is that allegations of fraud and related matters have to be very clearly pleaded and equally distinctly proved. So, where do we find the clear allegations of specific items of fraud in relation to the knowing receipt claim or indeed the dishonest assistance claim?
Well, in terms of, I can help you in terms of pointing to not further pleading so much as how it's subsequently been put in skeletons.
Yeah.
So, for example, in terms of, sorry, let me find the position. So, for example, looking at...
Are you about to leave the pleadings?
No, I was in fact going to... I was going to take you to some more examples of where dishonesty is pleaded elsewhere. So, for example, at the particulars of claim, at paragraph 111, so that's the bit we just looked
That's the one
at.
you showed us.
The dishonest assistance.
So I was going to suggest that if you look at between paragraph 39 and 49, that seems to be the start of the allegation. It's that Mr. Nuseibeh deliberately procured that Miss Scaife, who I think is at Burgess Salmon,
Yes.
would change the documentation that I was asking about earlier to ensure that the monies would not go into the fund's bank account but would go into the separate bank accounts of the two offshore entities. And it said, procured that was kept from Mr. Whitworth and Mr. Atabi.
Well, it clearly wasn't kept from Mr. Atabi.
Well, but that appears to be the first one that I've sort of obviously spotted.
And that was the pleading, but that was rejected by the judge in the light of the findings he made. So that's not going to help.
And it's a strange way of going about a fraud with presumably no suggestion that Miss Scaife was involved in anything untoward, and no suggestion that she couldn't have just checked wouldn't at any point speak to Mr. Mutaz.
Speak to someone else.
Or somebody else, or anybody.
Someone else. But
Or anybody at the fund, basically.
Well, she could have
Her client.
Yes. Well, in fairness, Mr. Nuseibeh, FCM London, Mr. Nuseibeh were authorised to give instructions on behalf of the fund.
Yes, but okay,
but yes, well,
it's a bit of a risky fraud to.
It's a risky
assume
fraud.
that Miss Scaife at the fund solicitors wouldn't
make
at
a
any
record.
point check with anybody at the fund.
And that the director of the companies where the money is paid would not notice the money appearing in the bank account would be sent.
Anyway, but that, as my lord said, that there's an allegation, the suggestion that so that the Mutas didn't know, was rejected. I think.
Right, I said we would stop
Okay.
at about 4 o'clock. How are you doing, and how much more have you got to go?
Well, I have dealt with, I think that really concludes my submissions on ground 2 and the background. I still have ground 1, which is no fiduciary duties, go through, which I will think about and shorten a little overnight. And ground, I think conspiracy shouldn't take long, and the ground relating to proprietary claim will take a little while, because as we will see, there are similar issues with there just being a great confusion as to whether it's a common law proprietary claim or an equitable proprietary claim. And various findings seem to be made that might enable some kind of common law tracing, but of course that doesn't help anyone here because various accounts had monies in them. And so I will take you through that. It'll be a similar exercise to what we've just seen in terms of the pleading and how it's put. I would still hope to finish by lunchtime tomorrow.
Right. Well, we started the day hoping and expecting that we would not take the full 3 days. So I think you really do need to make sure you finish by lunchtime tomorrow.
Exactly what you said.
And it's 10:30 tomorrow. I'm going to remind you in the court next door.
All right.